Welcome everyone. We're going to go ahead and get started. My name is Amy Meyer. I'm the Senior 2 for LADL 5, Law Office of Martin Lee. And I was going to open with a story about why these Fifth Amendment issues are so important. So if anybody is still trickling in, they'll just have to take my word for it, why this matters. This training grew out of a terrifying email that I got from the criminal appellate attorney for one of my former clients who had been accused of killing his wife. She wrote to say there was an issue as to the use of his statements to the social worker being used as evidence of his guilt in the criminal matter, where he was convicted and is now serving 16 to life. And also an issue as to whether he'd been appointed counsel and advised of his right to remain silent in the dependency case. So after I recovered from the heart attack I had, thinking, oh God, did I forget to tell him not to talk to the social worker about this, I went back and looked up the file and saw that actually the interview with the DI took place 2 days before he was brought in for his arraignment and before I was appointed. So luckily I did not ruin this guy's life. But I could have, any of us could have, if we're not careful in these kinds of situations. And so it's really important that we make sure our clients are not making statements against their interests that could come back to hurt them in criminal court. Now, I don't consider myself an expert on this issue by any means, and the more I looked into it, the more I realized that there aren't a lot of clear black and white answers as to what we should do in this case. So I was hoping that this could be more of a discussion of our shared experiences, and what strategies we might employ to minimize our clients' exposure, but with the caveat that when you're dealing with a particular case, this is something you're always going to want to talk to your supervisor about, because there is some weighing of risk that needs to be done, and you need to be able to properly advise your client so that they can make the best choice, because most of this ultimately comes down to your client's options. So, show of hands, who here has represented a client who is already facing charges in criminal court? Most people? Okay. Anybody represent a client where the allegations could have turned into a criminal case, but they hadn't yet been charged? Most people also. That's a little bit of a trickier situation. You can't contact their criminal attorney at that point and share ideas and get a sense of the exposure that they'd be facing and at least have that information to weigh in your decisions. You have to be a little extra cautious because there are so many more different ways that it could go at that point. So I wanted to talk about, first, does anybody have a story that was particularly dramatic about that they want to share? Anyone have a story that was not dramatic that they want to share? Okay. So there are three basic ways that your client could get in trouble in their criminal case. Making statements to the social worker, testifying, and settling in this court. So I wanted to talk about each of those in turn and also work through some hypothetical scenarios together so that we can talk about different strategies that we've used and what we could do to minimize our client's exposure. So there's a couple of piles of hypo number 1 spread out along the table. Let's get into small groups, 4 or 5 or so, and grab one of those and look it over and talk about what we might do. I'll read it for everyone just in case you don't end up with a copy.
You better get it right.
I'm
just kidding.
Yeah, that's it.
It's first thing. Okay.
All right. So you're picking up an alleged D-perp at the detention hearing. The report reveals he already spoke to the social worker at length denying the allegations, but he didn't provide an explanation as to why his stepdaughter, the alleged victim, would lie. He tells you he just found out, somewhere on the table.
Thank you.
He just found out that one of her friends was molested by an uncle and was receiving a lot of attention and support for coming forward. And he thinks his stepdaughter wanted that attention too. According to the detention report, the criminal investigation is pending and no arrests have been made. So what do you advise your client about how to proceed? So take a few minutes, talk amongst yourselves.
So,
I need to ask him what he said to the person, even though there's nothing.
Well, no, I mean, the issue is, he tells you about how he found out one of her friends was molested, so how are you gonna get that information in if he doesn't speak to the social worker?
I can't. Can I call her?
You cannot speak to the social worker.
No, not me. How am I going to do this? Try to ask her.
You could have one of, yes, you could have the microphone. That's the uncle in front. So how?
Hi, how are you?
I'm very social.
Why?
The question is, ask her this
But she doesn't know. Why doesn't tell them? So the issue is that he spoke to the social worker about allegations, but he never said why the stepdaughter would say
It's like a double-edged sword.
so why evidence not in evidence? But now you know that there's a real investigation pending. So it's this like delicate balancing act because there's another investigation pending. What I would probably do is say, listen, when you talk to the social worker, you have to know that you're talking to the social worker. So as long as you continue to, if you continue to try and make sure, you have to know that whenever you say the social worker is going to access by the lawyers, and if you want the social worker to know about this, and to know that his stepdaughter's friend was molested and received detention, he can tell that to the social worker.
And just if she asks another question, just tell her.
He can either like deflect or deny it, and like say that and that way you get it get it out. Now you're not going to be present most likely during that interview. So if the social worker asks what is risky, and that's what you can do to the client of the risks and the possibilities. You can say, listen, I can make a request if you want to be interviewed by the social worker that means that this information is not going to get in. Now, also you could say, is the mother aware of this? Make sure the mother takes this.
Well, and then also if the mother's aware of it, I can make sure that one, or the child.
Yes.
And that way you avoid the other.
Once we go
So if you said on your that's what you said, I can't keep it on.
no, but you can submit. So
And that has no, that's not information.
it's not an admission, it's a submission. And the thing is that you can advise the client here, you're getting the deal instruction. So all you're settling on is a watered down deed, like that's a very good deal. So I would advise my client to take it, and I would say we're just going to submit on it, but that you should take this account, especially because that's what I would advise. Although I would also probably talk to Martha about it.
Why can you not make a contract?
Because that can be used against you in a contract submission.
But if you plead no contest for your agreement is to strike off the account.
Well, because you're pleading no contest to inappropriate touching of a minor, that's still an issue. Now, the other thing you could do is, the other thing I would try to do behind the scenes is I would try to conference the case and say, listen, I can't have my client sign a waiver on this, but I'll just do my best and just say, Your Honor, I submit evidence. That way, You're not putting him in jeopardy at all. You're getting him home and you're gonna go to the language zone.
I'll leave it at that.
Okay, so we've had about 5 minutes to talk about it. Anybody want to start with what they would tell their client? I'm going to pick on Jessica then, because she's right here. What does your group talk about?
Well, we talked about a number of things, but one of the things that we talked about was, you know, sort of advising them of our role and that we don't represent them in criminal matters, but letting them know of that what we've noted in the detention report of the criminal investigation pending, and advising them to maybe to consult. Obviously, they wouldn't have a public defender yet, but maybe consult with an outside, like private criminal lawyer as to how they should proceed, but advise them of their right to remain silent and that they probably should not be speaking regarding these allegations to the social worker or really anybody at this time. And no polygraph.
Good point. Yeah, anybody else? Yeah.
I tell my clients, I say, look, when a detective comes and talks to you, or even a social worker, you tell them, you know, I really like to talk about this, but my lawyer said I can't. And
Absolutely.
put everything back on me, because I don't want you to come off like you're, you know, you're not cooperative, or you're not being open or forthcoming.
Right.
And that usually works. I had a detective call me, trying to say, so if he gives you permission, you'll talk to me? Okay. Obviously never. I was just commenting on, I had a case where the guy admitted he had a drinking problem, and I guess it blurred the lines, and he had fondled his kid, and then he got sober, but he was going to Victory Outreach, and he said, well, I'm not gonna lie. I can't lie. You know, I have to be honest. I said, but you realize the consequences of that. And sure enough, several months later, they went to his job, hooked him up. He was working at aerospace, making good money finally. He said, now I can provide for my daughter. I can be, you know, the dad that I haven't been in the past. They gave him 3 years in state prison, registered sex offender, for his being open and honest.
Right.
It doesn't work, so they got to protect themselves.
Right, yeah. A lot of our clients want to do what they feel is the right thing, and that can have really nasty consequences for them that go far beyond their dependency case. So that's something that you have to advise them about, and you also have to advise them that you're not even qualified, as Jessica said, to advise them on the full range of possible consequences, and that the best thing to do would be to consult with a criminal defense attorney. Now, most of them, if they haven't been charged yet, and therefore haven't been appointed a public defender, aren't going to have the resources to do that. So they may have to just err on the side of caution and not say anything to anyone. In addition to telling them not to talk to the social worker or the dependency investigator or the police, you can also request an order at detention that the social worker is not to interview them about the allegations in the petition. And that makes it really clear that you're the one taking the lumps, you're the one standing in the way, they're not simply refusing to cooperate. And do know that also sometimes the social workers just aren't paying attention to these things, especially if that order inadvertently doesn't make the minute order because the clerk misses something. I had a case, a D case, where I made that request at detention, and it even did make the minute order, and the social worker was just not paying attention and kept trying to interview him anyway. And luckily he thought to call me and say, hey, wait a minute, I thought you said they weren't supposed to interview me. And so I emailed county council, and we eventually got it straightened out. But the social worker just straight up violated that order, kept hounding him to talk about the allegations in the petition when they'd been ordered not to. So you also, whatever order you ask the court to make, you also want to make sure that your client understands not to talk to the social worker if that's the approach you're going to take. And that may be the approach to take when you have really serious charges possibly hanging over their head. This is also something that you do want to discuss with your client before you go on the record and make that request at detention. And unfortunately, that's a decision that you often have to make before you have a chance to talk to their criminal defense attorney, even if they do have one. Because how much time do you have to get on the phone with somebody before your detention is called, right? usually not enough. That's something that you can always walk it back later. You can always change that order if you decide that the criminal case is being resolved, they're taking a plea, it's all worked out, and it would benefit your client to talk to the social worker in this case. You can always walk that on, do an attorney order, something to modify that order. You can't put the genie back in the bottle once they've started talking with the social worker. So when you're looking over whether this is an order that you want to make, a couple things to consider: the severity and nature of the allegations. Have any of you heard of dependency issues getting tangled up with domestic violence allegations in the criminal court? Anyone? I haven't either. Or drug cases?
Can you give like an example of what you mean?
Well, I mean, the DA looking up the dependency file, or otherwise, you know, there being a situation where your client's actions in dependency court interfere with their ability to get the petition dismissed. You have?
I've had DAs sitting in the back of the courtroom.
Yeah. On which type of case?
Very serious, the serious cases, the F cases.
The F cases, right. Domestic violence, drug cases, they're a lot less likely to bother, in my experience. So just because there's a possibility of some criminal allegations pending doesn't necessarily mean that the same degree of caution is always warranted. E, F cases, even D cases, you need to be a lot more careful than your drug and domestic violence cases. There's also sometimes the fact that, you know, the possibility of being able to invoke the Fifth Amendment is a little bit of a silver lining. I think we've all had clients who manage to say the most damaging thing to their case every time they speak about it. And so even if they really, really want to tell their side of the story, even if you know, they're really champing at the bit, sometimes the best thing for them, regardless of the criminal case, is to say nothing. And being able to assert the Fifth Amendment when talking to the social worker, and if somebody tries to call them to testify at trial, is the best thing for their dependency case, not just their criminal case. So you want to look at whether there is even anything that they have to say that could help them, and then whether any of that could be gotten into evidence some other way. Is there somebody else who could testify to that defense? Is there somebody else who could provide that information without your client exposing themselves? In the case of your first hypo, this DPERP's potential defense saying that, well, she wanted to be like her friends. First of all, you have to weigh whether that's even a very solid defense. You know, is your bench officer likely to even believe that a child is going to make something up because it got her friend some attention? And second, if you think that it is a viable defense, could mom testify to it? Could you put the kid on the stand? Would the kid say that if she were called to testify? Is there some other way to do this without having your client talk to the social worker or testify? Okay, so second hypothetical, I will hand this out. And then grab your same groups or different groups if you're tired of those people. Okay.
I'm not tired of you.
Oh, good. There's so much more to be with
Well, now Marlene's in our group. This is a really good day for me.
So for anybody who hasn't grabbed one yet, or for people in Lancaster, your client appears in custody at an arraignment. He was already arrested and charged with murdering a rival gang member. He doesn't know who his criminal defense attorney is, whether he even has one, or when his next court date is. There are no statements of his in the detention report, and the JDX report has not yet been submitted. But your client doesn't recall talking to anyone from DCFS, although he says he's not sure. He admits to prior gang affiliation, but denies being currently involved or having anything to do with the murder. How do you approach the case? Take 5 minutes to talk about it.
Are those the allegations? Are those the allegations? I have a question.
Yes,
Are those the allegations in the detention?
Yes,
here, or
the
other
allegations are about him murdering a rival gang member and creating a safety risk, detrimental home environment, etc.
And are we just approaching this?
Yes.
Many times our clients are arrested, but then it's a DA reject. So then the question becomes, do they then the first thing you need to look at and figure out is it mere arrest or DA reject, or is it actually filing this requirement? The DA has assessed this is not whatever your client says, fuck it, that means a DA filing doesn't mean it's the court, but it's not what the people downstairs are doing. So you have to look at that. That's what, to me, more than anything, would trigger you shut up. So again, there may be cases where clients are arrested for DA reject, stupid for domestic violence thing, but they're never going to go back to the complaints programs. So you want to look at that distinction. Based on this, to me, it's like you don't talk to them. You don't think they're going to threaten to back into jail. Police may actually rearrest or put in jail.
Saying all the officers have personalities.
Oh yeah, young and fun. Yeah.
Investigators.
Yeah. It's fun, I guess. Welcome. You're in later one, right? Or no, you said which one? You mean, so that's 4. Okay. Yeah, no, so, you go with the brace. So she's either 4 in my corner, Brianna. Have I been there? Since May. 6 months ago.
Still learning out of the darkness?
Yeah. I mean, there's definitely always still learning points. Every day is something new. What's cool about, I guess, being here at least over 6 months is, you have pieces of your family from the start. So, like, you're handling the trial now, the review period, versus, like, when you first start, all your cases are new, but you're handling them at different stages. So, you're meeting parents for the first time at, like, the 2 or the 2 stage. Who are you? But it's cool to, like, from inception, like, walk them through.
Can we bring it back into the group here? Is there anything you can do about the fact that your client seems to have no idea what's going on in this criminal case? Anybody? Yeah.
So we can put an action request in our firm, and we have an investigator who has had really good luck finding people as public defenders.
Great. Okay.
And then we follow up with the public defenders.
I've also, on at least one occasion, been able to just call the main public defender's office and find out that way. There's some information in the last page of the handout about what you can do to look up information about your client's criminal case, how to find their public defender. But I think that if they have one, it's really important to at least try to get in touch and try to touch base with them. So you can search by defendant name or criminal case number on the court website. There is a fee if you don't have their case number. So that's something that you would want to have to maybe talk to your supervisor or firm director about, see if that's something that they would reimburse. It's usually a very small fee, less than $5. And then once you get their case number, any searches in the future are free if you're looking it up by that. But it is really important to know what's going on because you want to be able to put on the most vigorous possible defense, and you don't want to be hamstrung by considerations of their criminal court case if it does end up getting resolved before adjudication. So what about some of the other issues? What would you, assuming that the criminal court case is moving forward but it's not likely to be resolved before adjudication, what would you advise him to do? What orders would you request? How would you go forward with that? Anybody else? Yeah?
Ask that he not be interviewed by the
Yeah, I would definitely ask that he not be interviewed by the social worker. I would be worried about that social worker testifying as to his statements, whether he ended up confessing to her or even just made a statement inconsistent with the strategy his criminal defense attorney decided to pursue. For those of you who missed it at the beginning, I opened with a horror story about one of my clients who was convicted of murder based in part on statements he made to the social worker before I was appointed, and then she went in and testified at his criminal trial. And the prosecutor even used her statements in his closing argument. So that's up on appeal now, but that's a really scary thing that can happen. Anything your client says to the social worker, they may end up using against them in criminal court. Anything else? Any other considerations in this case? One thing that jumped out at me here is that if your client is convicted, he's probably going to get bypassed if it happens before your adjudication hearing. Could be due to length of incarceration, could be also due to serious or violent felony. And so you might want to be thinking about if he's going to be able to meet these criminal charges. If there's another plan in place, is the child suitably placed, or is mom likely to reunify if your client doesn't, or what other options might you want to pursue? This might be the kind of thing that I would just set for a no time waiver trial and just get it done and not let it languish and not let the social worker keep going back and bugging my client about it. If the criminal defense attorney comes out with something really earth-shattering that exonerates the client and puts it on in the criminal case after this dependency case is done, you can always file a Brandon C-388 to try to get that into evidence here and get the decision in dependency court reconsidered. But this is probably not something that you're going to be able to put off until the criminal case is resolved anyway. So it might be better to just get it done with as quickly as possible. Anything else? Any other ways that you can put on a case for him if you're not going to have him talk to the social worker or testify in his own defense? Any ideas? Is there anybody who could maybe put on an alibi for him? Anybody else who could testify on his behalf, who can say that, no, he was with me that night, or no, I know that he's not involved with this gang anymore.
Yeah, maybe if he's like in a program in the community, or he's like part of a church, maybe you can bring in his pastor.
I've heard LADL attorneys say before that, oh, my client's facing criminal charges, I can't do anything. And some people may mean that as shorthand for, I can't settle, I can't call him to testify. But I do worry that some people get the impression that you can't put on a case for your client just because they're facing criminal charges. You can absolutely call other witnesses. You can put on other evidence, even if your client is pleading the Fifth. When we get to the testifying section, there's two cases, Mark A. and Brenda M., where the 4th District Court of Appeal ruled that clients' independency do have a right to assert the Fifth Amendment privilege, and the court does not have the right to sanction them for doing so by preventing them from putting on other evidence or cross-examining the social worker.
But I have had Trenda Costa, when he was still on the bench, say he can make any negative inferences.
And that's another thing. So it's not actually true that you can make any negative inferences either. And this is jumping ahead a little bit, but since you brought it up, Evidence Code Section 913. California is unusual in this respect, in that it prohibits the bench officer and counsel from commenting upon or drawing inferences from a party's exercise of his Fifth Amendment privileges. So if somebody brings this up in argument, or if the bench officer says, well, I can construe his silence against him, no, absolutely not. Not in California, not since about the 1960s when this statute was enacted. In most other jurisdictions you can, but not here. Now, this doesn't help if you're in a situation where you bear the burden. If there's a 355.1 presumption, if you're filing a 388, if it's your burden to put on evidence and prove your case in that situation, and your client's not testifying, then you're maybe not meeting your burden, and they can, of course, look at the evidence that's there and say, well, you know, I think the department's made their case, or you haven't made your case. But they can't say that just because your client is choosing to remain silent, that they can make all those negative inferences against them, okay? And yeah, a lot of bench officers don't seem to know this. There's also an unpublished case where Zeidler did that. And the 2nd District called it problematic, but didn't even bring up the statute that says, no, it is explicitly not okay. So I'm not sure why this is so little known, but I kind of want to scream it from the rooftops and have everybody citing it. Okay. Let's see. So testifying, why it's risky, again. In addition to all the ways that speaking to the social worker can be used against him, when your client is testifying, they're under penalty of perjury. So if they lie, even if the things that they say are all in their own defense and not in conflict with their defense in criminal court, that can be problematic. In preparing this, I reached out to everybody I know who's working in criminal defense right now, and asked them if they had any horror stories, if they had any tips about how they would proceed. And the only other real horror story I heard besides the one that I opened with was from Daniel Wong. Some of you may remember him from LADL 3. Not from him directly, but from his senior colleague at the Ventura Public Defender. This was an F case. The dependency attorney, not one of us, somebody I think out in that county, had encouraged the mom to be really open and forthcoming with everybody and cooperate with the police and cooperate with the social workers and testify at her dependency hearing. And not only was the F count sustained and she was convicted of murder, but she was also convicted of felony perjury for her testimony in dependency court. So it can happen and it can be really bad, and testimony is one of the riskier areas.
This is where I'm a little confused.
Yeah.
So, correct me where I'm wrong. I had thought that if a client testifies in dependency, and this is why I'm curious about your case, any of the information that the client provides to the department, now it can be used by the DA to find witnesses, to prepare their defense,
Right.
but it can't be used in the DA's case in chief.
Right.
Unless our client testifies in the criminal case.
Right.
Then they can use their dependency testimony to impeach them.
Right.
So what confuses me, like when you're talking about like your case, if a client, let's say on an F case, talks to a social worker and admits that they killed the kid and the social worker, you're saying that the DA can call that social worker in the criminal case because that was an admission by the client?
So what happened in my horror story was that the client did admit to killing his children's mother to the social worker, and then the social worker testified as to that in the criminal case. Now that's up on appeal, and I am hoping that the multiple procedural problems with that will make it a viable appeal. But the fact is that it happened, and the criminal court judge let it happen. And we don't yet know what's going to happen with the Court of Appeal. The other story I just shared, where there were perjury charges involved, I don't have all of the details on that, but I think that what happened was not in that case that she admitted to killing the child. I think that she denied it, but that she got caught up on her own story and ended up facing perjury charges as a result of that. So, WIC 3, where did we go? So, 355.1 subdivision F states that a parent's testimony in a dependency case shall not be admissible in any other proceeding. Okay, but I think that what has been happening is the criminal court is not necessarily abiding by that. There haven't been, again, a lot of cases of this happening, and it's hard to say to what extent that's due to our being careful and not having our clients testify in these cases, because most of us make that call, right? Most of us advise our clients not to testify in their dependency cases when they have criminal charges pending. So there's never a chance to test that in the criminal court. But we have at least one case where that did happen in Ventura, based on the parent's testimony, and at least one case here in LA County where it wasn't his testimony but his statements to the social worker that were brought up in criminal court. And then there are also these two cases, In re Mark A and In re Brenda M, where the Court of Appeal held that the statutory immunity provided by WIC 355.1F is more limited than the Fifth Amendment privilege, and it does not provide the requisite immunity. So the Court of Appeal has recognized that 355.1F is kind of toothless, and that it doesn't provide adequate protection for our clients. The fact that it still is on the books can sometimes be a problem for us when we are advising our clients to take the Fifth, if somebody else tries to call them to the stand. Has anybody had a bench officer try to compel their client to testify when they wanted to take the Fifth?
Yes.
Which one?
It was Valskiba in Lancaster, and what she did was she said that no one could question about the exact underlying allegation, but kind of additional, it was really bad. So I was like objecting, you know, because she was, you know, going around the criminal allegation, but asking auxiliary questions, and then she started questioning.
And was this in testimony? The client was on the stand?
The county counsel called my client.
Okay.
We asserted the Fifth and did the Mark N assertion, and she said, we won't question him about the underlying criminal case, but I think I can question him, and she began questioning him about the mother, about certain things. She was going all around it, but he was still providing information that could eventually hurt him on the criminal case.
And so that is not okay for the judge to do. There unfortunately aren't a lot of dependency cases on the Fifth Amendment, but if you go to the next page, I've put a summary of a series of cases on what the Fifth Amendment means, when you can assert it, especially in civil cases. It absolutely does apply in civil cases, and it protects not only against direct admissions, but testimony that would form a link in the chain of evidence that could implicate the defendant. And it's not limited to criminal charges he's currently facing. It can be anything that he reasonably believes could be used in a criminal prosecution or could lead to other evidence that might be so used. So yeah, you absolutely want to object, bring these cases up, and just don't let them get away with that. Now, as to whether they can take the stand at all and answer any questions at all, I think the answer to that is yes. It does get a little bit gray around which questions they can answer and which ones they can't. If they start to answer questions about the subject that they're then going to take the fifth on, that's problematic. That can create an implicit waiver. But let's say there's some type of severe abuse allegation, physical or sexual, that is potentially tied up with criminal allegations they could face. And then there's also a mental health count that's totally separate from that. They can testify about their mental health if answering those questions is not going to lead back to somehow implicating them in the criminal case. And you can use that to your advantage as well. If your client has some good things to say that could help them in that, they can testify as to those things. It can get a little bit murky when you're dealing with, say, an E or an F case, and you want your client to testify about their progress in programs and their insight, because what is their insight if you're not going to talk about what actually happened and what they needed to gain insight about? So that's someplace where you need to be very careful and maybe err on the side of caution, and look for other ways to get their progress into evidence other than their own direct testimony. Okay, any other questions on that subject? Okay. All right, so let's move on to our third hypo. Okay. So for Lancaster, for anyone who hasn't seen theirs yet, you represent a mother on an F case. The court already made an order at your request for the social worker not to interview her. The police have interviewed her but have not charged her. Her child died of head trauma. She thinks it could have been from an accident that occurred a few days before his death, or possibly an act of abuse during a visit with his father, a man with a history of violent behavior with whom she shared custody. They don't live together. Your expert does not believe the trauma was accidental. Okay, you've consulted an expert on this. They said it was not an accident. Your client wants to testify at trial. What do you advise? So take 5 minutes and talk about that.
That contradicts your testimony, so I would take like maybe it's not a little bit. I don't know, like she may have already not having the allegations anyway, so maybe still in my closing argument. Yeah. Try to pin it on her. That's tricky though too. We don't have enough information. Right. I mean, she knew that yeah, that's she's been interviewed. There's not even been a so this made it very Yeah, but you don't want her saying, you put on an expert. You might not want to call it expert either.
No.
Depending on the,
Never happened.
yeah, unless you say,
Or the expert.
Okay, so what do you tell your client in this case who wants to testify? Anybody? Yeah.
Don't.
Really, really don't. Why not? What are some reasons you can give her?
Just because the police haven't filed anything yet doesn't mean they won't, especially if you put more statements out there into the world to be discovered.
Right. They might just be waiting to see what you do so that you can build your case. If it's going to be a murder charge, obviously there's that you're never going to be out from under the possibility of that being filed. Even felony child endangerment, statute of limitations is 3 years. And you can be charged with that even if you're not the perpetrator of what was done to the child. Just like if you can be failure to protect in an F count here, you can still be charged with felony child endangerment for what your boyfriend did to your kid in criminal court. And they can hold off on filing that until everything is all resolved in dependency case and you've already been tried and bypassed and potentially even TPR'd. So As to the possible defenses in this case that she could testify to, what would you tell her about those? What about her theory that it's an accident, that she wants to testify to that?
We have an expert witness that suggests it's not like accident.
Right, so if you have her testifying about that and then you don't even have any expert testimony to back it up, and probably the department's expert is going to say, no, it couldn't be accidental, probably not going to help her in this case, right? What about her theory that it could possibly have been the father? Is that something that she could testify to?
It doesn't really help her. It's kind of what you already talked about. So you get stricken from being the cause, but you're still a failure to protect, and it's still a possible criminal.
Exactly. If he has a violent history, yeah.
Now I'm going to play devil's advocate, because I absolutely agree that she shouldn't be talking to the police anymore. However, to play devil's advocate, if once you talk to your expert, if you can develop a very tight timeline, okay, and obviously, if the kid is coming back from a custody situation with bruises and all of that, and she had noticed, but a lot of these times, like it could be shaken baby, it could be a one-act situation. So it's the whodunit, because you have two theories of the defense. You have an underlying pathology, or you have the whodunit. So if you have a really tight timeline, and your expert will testify as to that timeline, the question then becomes, if she's done with the police, they've done their investigation, so if they come back to talk to her, you say, no, I don't want to talk anymore. But can you, now the issue is, along with your expert, it may be absolutely intentional, but can you bring in your expert to say it's an intentional, and this is the window, and guess what? She didn't have custody and control during that window, and could she testify to that?
And the risk, I think, there, yeah, go ahead.
I was just going to say, I agree. I would query whether she needs to testify as to that. Is it clear throughout the reports without her testimony as to the window?
The question is whether we call her or not if she gets called. We have to prepare.
Right.
We have to prepare that client, because we may not call her. But could she? The question is, do we assert the fifth or not? And in that situation, if we would put on the expert, the tight timeline, other people who knew the custody thing, but you have to prepare her. What if county council calls her to the stand?
Yeah.
Do you assert the fifth, or you let her conform her testimony to your theory of the defense?
Provided, like you said, I just worry about it then turning into the sort of link in the chain of events if there was then any reason that she should have or could have known that this man was abusive or violent, and given the facts we have in this case, I would be very concerned. But yeah,
Right, and so those are the things you have to weigh. He has a history of violence. Does he have a history of violence toward children? Could she have known or reasonably suspected that something would happen? Should she have fought for full custody at some point? Did she try to fight for full custody and lose? Those will all weigh to whether that's a viable defense that you could pursue. And then the next question is, do you have her put on that defense through her testimony, or do you try to get it in some other way? And if there's another way to get it in, that's probably going to be safer. Now, again, also, got to worry about if she testifies, possible perjury charges. That's something that you want to give her a heads up about. If she lies on the stand, that's going to be a problem if she gets caught lying on the stand. And again, as I think somebody brought up, possibility of charges being filed later. Another thing, when you have a client who really wants to testify, when you think that they shouldn't testify, especially if you think that there's any possibility of dismissal, if you don't put on evidence, don't forget about a 350C motion. That allows you to try it both ways, okay? Wait till county council, minors council have put on their case, make your 350C motion. If it gets dismissed, great, your client is not going to mind that they didn't get to testify in all likelihood. And then if it isn't, then you move forward with presenting your evidence, including their testimony or possibly other people's testimony. You can also consider if what she really wants is to be heard and to, if she's not so much fixated on testifying as to the particular circumstances of what happened, you could consider calling her to testify at dispo only, if the F count is sustained. the factors in ZG, parents' history, current efforts in fitness, strength of the bond. You can have her testify to those things without necessarily waiving her Fifth Amendment privilege about the precise circumstances that led to dependency jurisdiction. And that might be a way for you to, I don't want to say split the baby. Forget I said anything. All right. But again, you do want to be careful with getting into anything along the lines of insights she gained in her programs, because that is skating dangerously close to waiver. Even if you're already at DISPO, county council then might try to pry open the door as to, well, you know, so you're saying that you now know you need to be protective from this, this, and this. Are you saying you weren't protective before? And that's something that you don't want coming back to haunt them. Really quick before we wrap up, no contest, please. Has anybody had experience with no contest pleas being used against their clients in criminal court? Anybody? I haven't either, and I haven't heard of it from any of the people that I've talked to. I think it's possible that we are overestimating the risk when it comes to no contest pleas. On the other hand, I think that sometimes we may overestimate the benefit of no contest pleas. If all they're doing for you is watering down language, what's the point, right? If it's the difference between suitable placement and home of parent, or the difference between FR and bypass, that's something maybe worth talking about, okay? And again, ideally you want to consult with your client's criminal defense attorney and get the go-ahead before you do this. I'm also not sure whether the whole submission versus no contest thing makes a difference. Anybody have any thoughts on that? Emily is nodding, so I feel validated.
Well, because, I mean, I've had the same experience. I always tell the people that I'm training to go ahead and do a submission if that's what you want to do when there's a pending criminal case or we're not sure what's happening. And I've done that successfully without any problems. But like you said, I've also never heard of it. I think it's just sort of a cautious approach because I've never heard of a no contest plea being used against anyone either. And I love what you said about watering down the language, because at the end of the day, a B is a B is a B, and that's what Marlene told me a million years ago when I started, and I take it to heart.
Right. So, you know, again, ways that you can deal with this, you can still argue the petition, you can still put on other evidence, you can have a full trial without your client's statements to the social worker, without your client's testimony. You can still fight it. You can still make nexus arguments. You can still, in your D case, argue Rubicella E if it's just the stepdaughter. Come on. You know, don't just think that your options are Melinda S. submission or, Your Honor, I object to the court taking jurisdiction for a lack of evidence, no showing of nexus. You can do a case without doing anything to increase your client's exposure. But if you are getting something meaningful that really makes a difference, at the very least make your best efforts to reach out to your client's criminal attorney if they have one and talk about the approach of settlement that you're considering if you are going to get something really valuable for them out of it. Because, you know, between the different standards of proof, preponderance of evidence versus beyond reasonable doubt, and between the different standards of what has to be shown, in dependency court, all you need is risk to a child. You don't even need parental fault or neglect anymore under B, right? And so you can, if we're going back to hypo number 1, we don't really have time to talk it through, but you know, if you are being offered a settlement on this case that gets the kids home with mother, there could be any number of ways that your client's criminal attorney could deal with that in criminal court if the prosecutor did try to introduce it. They could argue that it's unduly prejudicial and try to get it excluded entirely. They could, if it does get admitted, argue to the jury that he did this so that his kids could get out of foster care. Or, you know, he did this to spare his emotionally disturbed stepdaughter the horrors of having to testify in dependency court, and, you know, so that she wouldn't have to go through all of this, because it is traumatic for children, even if it isn't the truth. So there may be ways that they can mitigate that damage, and if it's really something good for your client, it's something that you might want to consider. So we have about a minute left. Any questions? Okay then.
Great. And so, I've never heard it before. Thank you for being sorry.
Absolutely. Thank you.
Okay. Yeah.